Ready for the dictation? Start. It also states that floor level of the shop is lower than the existing main road level, thus attracting dampness from river water and dry weather flow. Full stop. Learned counsel for the appellant submitted that no doubt the respondents had also examined a retired engineer as RW4 who had filed his affidavit, and his report was accepted as R1. Full stop. However, the report filed by RW4 did not discuss the conditions of the shops, and it only mentioned about the photographs of the roof and flooring, which was taken with the help of a digital camera, and the report also mentioned in the front side stating it to be in a good condition. Full stop. He thus submitted that the findings of the courts below were totally perverse, which relied upon the report of RW4 and ignored the report of PW3 para change. Second submission of the learned counsel for the appellant was that the subsequent events which happened fortified the report of PW3 inasmuch as in the year 2012, when the appeal of the appellant was pending before the additional district judge appellate authority. Full stop. This event, according to him, proves that the premises are in dilapidated condition and unsafe for habitation. Full stop. He submitted that even when this fact was brought to the notice of appellate authority as well as the High Court, these courts have not taken notice of this subsequent development, though they were supposed to look into the same. Full stop. In his judgment dated April 30, 2010, the rent controller discussed the expert evidence led by both the parties, and after detailed examination of both the reports, he formed an opinion that the appellant was not able to prove that the shops were in a dilapidated condition para change. Thus, after examining the expert witnesses who are produced by both sides, the rent controller returned the aforesaid findings, which finds were approved by the appellate authority as well in its judgment dated September 17, 2012. Full stop. We find that the view taken was plausible, view which cannot be considered as perverse. Full stop. The revisionary jurisdiction of the High Court is limited, and therefore it rightly observed that no ground for interference with the finding of fact arrived at by the courts below was made out para change, insofar as the contention of the appellant based on ground alleged subsequent event is considered, except arguing that it was taken before the appellate court as well as the High Court. No material is produced to support this submission. Full stop. Grounds of appeal filed before the appellate authority or the copy of the revision petition has not been placed on record. Full stop. Moreover, judgments of the appellate authority as well as the High Court do not reflect that such a contention was raised before the said courts. In the absence thereof, the alleged subsequent event cannot be taken into consideration. Full stop.